The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning. Welcome to council and to those watching on the Supreme Court live channel. I will ask Mr. Doug Shima, the clerk of the Kansas Appellate Court, to please call the morning docket.
Thank you, Your Honor. May it please the court. The 9 a.m. docket for Friday, October 29th, 2021 consists of one case, appeal number 121181, State of Kansas versus Mark Holley III, Sedgwick County, briefs both sides. Your Honor, the appellant has reserved 4 minutes rebuttal time. We are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please state your appearances?
Mr. Holley, the appellant in this case, appears by counsel Michelle Davis, present and ready for argument.
Thank you, Your Honor. The state of Kansas appears by Assistant District Attorney Lance Gillette, present and ready for argument.
I might just briefly explain that this case is before us today in a slightly unusual posture, in that the court had issued a decision in the matter and then granted a motion for rehearing. The court directed the parties to file supplemental briefs answering 7 questions. And once those briefs were filed, we did set the matter for oral argument, which is what brings us here today. With that, Ms. Davis, you may begin your argument.
Thank you, Chief Justice. To give a brief factual summary, this is a case that started out as a drug buy sale. Mr. Holley was the drug buyer, and the drug seller ended up deceased. The state's theory of the case was that Mr. Holley, this was a robbery, and that this was a felony murder because the drug seller was killed in the commission of the robbery. Mr. Holley's theory of the case was that he went to buy drugs and it was the drug seller who tried to rob him. And there was evidence to support that claim. The drug seller had a gun and the gun had jammed, but someone had tried to fire that gun and it was found at the drug seller's feet. The district court in this case agreed that the evidence supported a self-defense, excuse me. The evidence supported a self-defense instruction. The district court did not give that instruction because the state argued and the district court agreed that self-defense is not available to a person who is charged with a forcible felony. And several months earlier, of course, this court had issued a decision saying that the charge alone does not bar the self-defense instruction and claim that there was a little bit more nuanced standard in place. So this court agreed that the instruction was factually and legally appropriate. I think that the issue that the state raised in its motion to reconsider is whether the error was harmless or not. And so I'd like to focus on that. Of course, when the judge said, I'm not going to give a self-defense instruction. And again, this is at the prosecutor's urging. The prosecutor also had the district court instruct defense counsel not to argue that claim to the jury. So basically, you're in a situation where the jury is not instructed on what needs to be met in order to find self-defense. And also, more importantly, with the 2011 recodification, the legislature has mandated that it's the jury was not told that it's the state's burden to disprove the claim beyond a reasonable doubt. So I think that the easiest way to understand this, and I'm raising my hands, I'm trying to do something here. You've got basically the state's theory of the case on one side, and you've got the defense theory of the case on the other side. And to me, that's kind of like a seesaw. Those are both kind of level. And the jury is looking at this in that way. I think that once you instruct the jury that the state has the burden on the defense, so that the jury will consider the defense, as well as that the state has the burden to disprove the defense, I think the scale goes up a little bit more on this side, or a lot more on this side. and is not so much of a seesaw. Because basically, it's human nature when someone makes a claim to say, well, have they proven that claim? And when you say that the state has to disprove the claim, it has to disprove self-defense beyond a reasonable doubt, all that it really takes for an acquittal is for a juror to have a reasonable doubt as to whether the state had disproven Mr. Holley's claim of self-defense. And all it takes is one juror to do that. And so instead of having this sort of seesaw, which theory of the case do we believe, we're much more up here where has the state disproven Mr. Holley's claim beyond a reasonable doubt? Have they disproven that to me beyond a reasonable doubt, or is there a reasonable doubt here? It's not up to Mr. Holley to prove.
Counsel,
Yes.
let's take everything you just said and sort of, for purposes of my question, just say we agree with you completely on everything you just said. And really, that was a big part of the initial opinion, which was issued and has now been withdrawn, of course, because we're rehearing it. But we agreed with you that, in fact, the self-defense instruction should have been given here. What is your view of how procedurally we ought to structure these kinds of problems when the state still has out there hanging the notion that self-defense might not be available depending upon what the jury finds with respect to the underlying forcible felony? Does that question make sense?
Not exactly.
Well, we have this plumber format to try to decide whether or not to give a self-defense instruction. And again, I've said for purposes of the question, we agree with you that the instruction should have been given here because, in fact, just being charged with the underlying forcible felony is not sufficient. And here, I don't even think Holley was charged with it. But what happens, in other words, self-defense is not legally available if the jury concludes that, in fact, the defendant was engaged in a forcible felony. So how do we procedurally account for that in our plumber format? Once you've given the self-defense instruction, you kind of can you take it back? Should we come up with a new instruction that would tell the jury to disregard self-defense if they conclude that the forcible felony was committed? I'm just asking for your view of how we ought to.
And I think I'm going with the Astorga case, if I'm getting your question correctly, which is the pattern instruction where you inform the jury on the defense, the law applicable to self-defense and the state's burden of proof to disprove that defense. But you also instruct the jury that the forcible felon is not entitled to use force. So the jury knows that if they believe the state's version of events and they believe that the state has disproven Mr. Holley's claim, then force is not available to him because the jury is finding and agreeing with the state that he was committing a forcible felony. And so that way the jury knows and the jury can deliberate and the jury can weigh. And
do you think that instruction is sufficient? Or because arguably it seems to me it might be confusing to a jury.
Mm-hmm.
In other words, do we need something that's more explicit?
I'm not opposed to something that's more explicit. I think my main concern here was just making sure that the jury was adequately and fully instructed on the law. And if you think there needs to be something more explicit, I'm not opposed to that, as long as the jury understands the state's burden of proof here and they can really deliberate the defense theory of the case, then, perhaps that'd be fine. I'll think about that and take a look at the instruction and come back on rebuttal if I have anything else to add.
Pick instruction 52.230
Mm-hmm.
basically says a person is not permitted to use force. It touches at least upon and maybe is the type of thing that you proposed.
Mm-hmm.
And so I would be curious if there was any discussion of the use of that pick instruction during this, the instruction conference or otherwise in this case.
No,
don't-
I'm sorry, Justice.
Go ahead.
No, this was a case of clear error where the state misled the district court and gave the district court the wrong law. And so the state was just operating under an incorrect understanding of the law. So they never even got that far
Okay.
because they just said that once the state charges a forcible felony, the defense doesn't get to present their theory of the case. It's really kind of.
Am I right that, and I might not be, but my recollection is that Holley was not in fact charged with the underlying forcible felony here?
Yes, that's correct. He wasn't charged. The only conviction in this
There were
case
other ag robberies that were folded in, but they weren't connected to the actual felony murder. Is that correct?
Yes, that's correct. Yes. So I will reserve my remaining time for rebuttal unless there are any questions.
Well, I will ask one more question related to harmlessness. What's the state's primary argument here, as I understand it, is, hey, the defendant might be right about all this self-defense stuff, but look at the way the jury was instructed on felony murder, because that instruction includes all the elements of the underlying forcible felony. And the jury found beyond a reasonable doubt that those elements were met. How would you respond to the state's position that, as a matter of law, renders these instructional errors harmless?
I think it goes to that weighing equation that I talked about earlier, that when the jury only has the choice between felony murder and not guilty, with self-defense instruction, it's an affirmative defense. So Mr. Holley had already acknowledged that he did commit the act and that he shot the person. And the only thing he had going for him was that my actions were justified.
Would you agree that self-defense is not available to the defendant if he was guilty of an aggravated robbery of the victim? Would you agree with that as a matter of law?
That's correct, but it's our position that the jury couldn't adequately weigh this case
without
the instructions.
That goes directly to the question. Is the jury supposed to weigh the claim of self-defense when it considers whether or not the defendant is guilty of the underlying forcible felony?
Then you're going back to Justice Nuss's logic that without the self-defense instruction, you're clearing the way for a trouble-free prosecution. The only choice the jury has is not guilty.
That's not exactly where we're at, because we would be saying that, yes, the jury was supposed to have been instructed on self-defense. But it seems that there's a disconnect between the claim of self-defense, which is a claim of a legally justified killing, and how does that self-defense instruction really help the defendant when it comes to the underlying forcible felony?
Because it's bringing in reasonable doubt. It's bringing in reasonable doubt. It's not saying we think Mr. Holley's version of events is stronger than the state's version of events. It's saying I, as a juror, have a reasonable doubt as to whether the state has disproven Mr. Holley's claim. That's what it is.
How could that be if self-defense is not a defense to aggravated robbery?
But it adds a burden to the state to disprove his claim beyond a reasonable doubt.
Not to disprove the ag robbery, right?
Right,
but
you can't
to do with the ag robbery.
That's true. But if the only choice you give a jury is not guilty or guilty of felony murder, if that's the only choice they have, and you've already admitted to the killing, and the state doesn't have to disprove his defense, that's all they've got. That's all they're left with.
I guess I'm just asking you to.
I don't get very many cases where the jury goes to the judge, we don't like these choices. We think he did something, but we don't like the choices you've given us. Could you give us another choice? I've never really seen that.
I think I agree with you that if it's a straight one or the other choice, your argument makes sense. I guess I'm asking you to respond to what I think is the state's argument that, hey, this was not a pure felony murder or not guilty because the jury was instructed to first consider the elements of aggravated robbery. So they did consider the elements of ag robbery, which arguably makes it not just an either or.
Yeah, and I guess I guess I just can't agree with you on that. I guess I can't agree with you that that's the way people think. I think without the instruction on the law, the jury's not thinking about that. If you don't give them the instruction.
Is it a fair characterization of your position to just say, commonsensically, we know how juries function, and when you take away the self-defense claim, it really taints the entirety of the jury's deliberations, and we can't say that the jury is sophisticated enough to sort of parse out the ag robbery as a separate legal question. I mean, that's kind of what it sounds like you're arguing. I just want to understand.
I'm arguing that, but I'm also arguing reasonable doubt. A jury, the way people, if Mr. Holley is asserting self-defense, Mr. Holley, if his defense here is, I wasn't the one robbing, I was being robbed. So the jury's looking at that. Did the state prove their version of events, or is Mr. Holley's claim stronger? Has Mr. Holley proven his claim? They don't look at, without that instruction, they don't say that added additional element is, has the state disproven beyond a reasonable doubt the claim of self-defense? They don't look at that. That's an additional thought for a jury to consider. And you have to tell them that. You have to tell them that the state has to disprove that. Otherwise, they're looking at it as which version of events is stronger here. It's a balancing equation. Once you take that balancing equation away, you bring in reasonable doubt as to whether you add to the state's burden. And you bring in an additional element.
That does make sense.
So I guess a juror could sit there and say, I don't think Mr. Holley's version of events is very strong. I think the state's version of events is pretty strong. But what's the state's evidence here? They had one witness, one eyewitness, and she was Mr. Holley's friend. She's not going to admit they went to rob Mr. Holley, right? And so a jury's going, it seems to me like I kind of believe this version. This witness was pretty credible to me, but I got a reasonable doubt here. Mr. Holley, maybe the state really hasn't disproven his defense. Sure, Mr. Holley hasn't proven to me that he was being robbed here, but has the state disproven that? Do I have a little bit of a reasonable doubt here? That's what the jury didn't get in this case. That's the instruction they didn't get.
So this will be my last question, I promise.
Okay.
Would your argument be the same if the state had actually charged the underlying ag robbery here and the jury had returned a guilty verdict on the ag robbery? Would you make the same argument?
No, again, yes, I would make the same argument because again, you haven't added that additional layer that can bring in reasonable doubt. Where with the instructions the way we have them right now, all it was the state's case was stronger than as to who was the robber here, which case was stronger. And the verdict only reflects that the state's version, the jury believed the state's version more so than Mr. Holley was robbed. But we didn't get that additional layer then for the jury to consider, do I have a reasonable doubt here as to whether maybe Mr. Holley was acting in self-defense? And the state, it's not that Mr. Holley hasn't proven that to me, it's that the state hasn't disproven that to me.
I guess I need to jump in. I'm still not tracking, and that's probably my fault. But let's assume that the state had charged the ag robbery, and there were 3 jury instructions that we're concerned with. The first one asked the jury whether the defendant committed the ag robbery. The second one is the self-defense instruction that you didn't get. And the third one is the felony murder instruction. If the instruction said that at the end of the first instruction on ag robbery, if you decide, yes, the defendant committed this crime, skip the second instruction on self-defense and go straight to felony murder, Is that a problem?
Yeah, I don't think that's what I think the instruction just tells the jury that the forcible felon, if you find he was committing a forcible felony, then you're not entitled to use force. So we have that instruction.
But in my hypothetical, have
Mhm.
we created a problem? I guess I'm framing this a little more into, and I know special questions kind of thing, but if you sequence the instructions in a way that first have the jury focus on the aggravated robbery, but then tell them, once you've decided that, you get to skip the self-defense.
I don't think they skip it. It's given to them as a viable theory. It's an affirmative defense. It says my actions were justified.
I don't understand.
That's all
And I don't understand how it's a viable defense if the jury finds the forcible felony. You're not entitled to self-defense as a matter of law if you're guilty of the forcible felony. So that's why you would get to skip it.
Well, I just don't know how else you fully instruct the jury on the law applicable to each case. I mean, your only other option is to say he's claiming self-defense, and I mean, you don't do that to the state. You don't say, well, skip the state's elements if you agree that he was using self-defense. I mean, at some point you've got to instruct on the law that's applicable to both sides, and then it's a jury question. And I don't know how else you get around that. And plus, the other instruction you need to add is the burden of proof. That's the other one that wasn't given, the defense burden of proof. There are three instructions, really. You've got the defense burden of proof, the self-defense instruction, and basically that's just saying, I mean, with self-defense, you do that. You say use of force is justified under these circumstances. And you explain to the jury the legal concept of self-defense. And then you say, but you can't consider that legal concept if you find that he was committing a forcible felony. You're just giving them the law. I guess I disagree with your word skip. I think you're just giving them the different theories, and then the jury weighs it out and decides, has the state disproven Mr. Holley's defense or not? And do you have a reasonable doubt about that? You may think this was a robbery, but are you sure? That's the additional equation that comes in. I don't know how you as a court do anything different. I mean, that's why we have jury trials. That's what we need juries to decide. That concludes my comments, unless there are other questions.
I'm not seeing any. Thank you, Ms. Davis. Mr. Gillette.
Thank you, Chief Justice, and may it please the court. I'm going to start out with a question that was posed about whether or not we charged the underlying aggravated robbery, and I want to both correct my original brief and clarify something that I've mentioned in my supplemental. We did not, but the aggravated robbery itself was incorporated within the felony murder charge, and it was appropriately instructed on within the felony murder instruction. So I wanted to start off with that point so that we're all on the same page here. My next point that I think I would pivot to is, how are courts supposed to view the evidence that's been presented in this case? I think that the only agreement that the parties have at this point is that the court is supposed to consider the evidence. The question, though, as to whether or not that evidence is sufficient to justify a self-defense instruction remains open. So that's the first point that I think needs to be considered here. And
what's your position here, Mr. Judge? In this particular case, we've determined that a self-defense under the Plummer rubric would have been appropriate.
My response to that would be, I think that this court's original opinion interpreted the state's argument a bit too broadly as far as the extent to which we conceded that this was factually appropriate. And I think that what both I'll go ahead and talk about Plummer, because what it requires is sufficient evidence viewed in the light most favorable to the defendant or the requesting party. The question still remains open. What is that sufficient evidence? And for the answer to that, I would direct this court to both Bartlett and Haygood. Now, in Bartlett, while we know that district courts,
Let me, Mr. Gillette, I'm
yes,
sorry, I'll just interrupt you and I apologize for doing that, but I want to get what I think is an important question on this point, which is procedurally speaking, sitting as an appellate court in review, we don't decide whether the evidence is sufficient to make the instruction factually appropriate, do we?
I think that you can.
We would
review
only
for harmlessness.
review, in the Plummer framework, we would only review a lower court's determination about whether or not the evidence is sufficient to make an instruction factually appropriate. But the problem here is the district court never conducted that analysis because the district court found, based on the state's argument, that the instruction was not legally appropriate. So the district court never actually conducted a factual review, other than maybe some comments in the record that, but for the legal inappropriate.
I'm sorry, the last part of your question cut out.
I'm sorry about that. I'm just asking you to, in the midst of your discussion, to talk about the procedural difficulty of the fact that we don't have a lower court determination of factual appropriateness, because the issue was cut off, the legs were cut out from underneath the claim by the legal conclusion that the instruction was not legally appropriate.
And I think that is a fair way to view the record, but I think that it's also fair to review this record and find, I think that this court can review the facts that are in the record. They are settled. And as part of that analysis, it's something that it essentially occurred in Bartlett. This court reviewed the factual analysis and found that the denial of a self-defense instruction as a matter of law can be appropriate. The Haygood concurrence conducted a similar analysis. So I think that we can approach it from that point of view. And so I think that is the appropriate standard for this court to utilize. We have to look to the statutes, and in order to justify a claim of self-defense, there must be sufficient competent evidence that a rational jury must be able to reasonably conclude self-defense is justified. And reviewing this record, that evidence does not exist. There is not evidence that could have allowed a reasonable jury to conduct, a rational jury to reasonably conclude that self-defense was applicable here. In the first oral argument, there was some discussion about my editorializing on the facts, and I think that is the point that I was trying to make clear. There is no way to review this record to find that a rational jury could reasonably have concluded self-defense was merited here.
Mr. Gillette, but why is that a legal appropriateness? Why isn't that a factual appropriateness? I don't understand why that's legal. I mean, I understand we're using the statute, but the statute requires, you just mentioned twice, that you look at the record and you look at the fact.
Correct. And it becomes a matter of law. It's a mixed question of law and fact. An instruction on self-defense is only legally justified if there is sufficient evidence in the record upon which a jury could reasonably conclude self-defense was an excuse.
Would you concede in this case that there wasn't enough, or that there were enough facts in this case that to factually justify?
No, I do not concede that point, and that's what I want to make clear. All that we have here is the defendant himself portraying himself as the utter and complete font of truth. This court identified two possible pieces of evidence that could have supported him. Number one was the bullet strike on the home near the scene. However, I would also direct this court to consider the fact that was described as a possible bullet strike, and we had two seasoned crime scene investigators indicate that not only was it a possible strike, but it was old. it was not fresh. There were no paint chips, no brick, no bullet fragments that would suggest this occurred anytime in the recent past. The second thing was the fact that the victim was found with a gun near his person, near his body. Now, we had Amari Reed.
Let's assume for a moment, because I think now we're just getting into the other case, what we heard before. But let's assume for a moment that, that there was enough. Okay, that, he testified, and also, the gun was found underneath, it looked like that he wasn't able to discharge the firearm, but that it was self-defense, was factually appropriate. Then let's focus a little bit on what you described here as the harmlessness analysis.
Sure. And I think that is again, if the court were to find that there was sufficient evidence, then we do shift our analysis to harmlessness here. The first thing that I would point out is that the standard of harmlessness that should be applied in this case is the statutory standard. While a defendant has a constitutional right to present a defense, they do not have a constitutional right to present any defense under the sun. And self-defense in Kansas is a purely statutory creation. And so under that standard, this court's required to determine whether there is a reasonable probability that the alleged error affected the outcome of the trial in light of the record as a whole.
Mr. Judd, I hate to do this to you. I'm so
You're
sorry.
fine.
Let's say that we disagree with that, and it's the constitutional test. Can I hear your argument on that?
My argument's the same for either. As I set it forth in my supplemental brief, under the constitutional standard, the question is whether this court there's a reasonable doubt that the error complained of will not or did not in fact affect the outcome of the trial in light of the entire record. Essentially, the state has to prove there's no reasonable probability the error affected the verdict. So what do we look at here? And what we have here is that the jury unquestionably resolved the question of whether or not this defendant could have ever been acquitted on the basis of self-defense. And there was a lot of back and forth about how a jury can.
Because the jury was not presented with any option for self-defense in this case, correct?
That's correct. Except I would explain what you have to consider is that the only evidence that could have supported self-defense is the exact same evidence that the defendant attempted to rely on to support his claim that he was not engaged in an aggravated robbery. The facts are the same.
But I think what your opposing counsel is saying that the burden of proof, where does it say that, the state has the burden to disprove the self-defense?
The state always has the burden to prove all of the elements of a crime beyond a reasonable doubt. And what the jury was instructed on here is that in order to prove the felony murder, the state had to prove that the defendant killed Deshaun Smith while he was committing or attempting to commit aggravated robbery.
But isn't that an after the fact? I mean, right, we could say that all the time. There's no, that error was harmless because look what the jury found.
That's exactly right. And that's what I'm asking this court to do, because you do review things after the fact. That's the entire point here. There is a timing question.
Right. But the question really is, was the jury given all the information it needed? Just like the decision where we said it's not enough to just charge a forcible felony. Let's say it's not a listed forcible felony, but it's not enough to just, charge it.
Right.
It has to be proved.
I agree. It's not enough to charge it. There must be there must be sufficient facts to support it. Well, and that's the point here. Those are the same that the jury would have considered if they had been instructed on self-defense. And I know what we've talked about, there would have been a second and a third instruction potentially given. And the question of whether or not that makes any difference. Well, we presume that juries follow the instructions that they're given here. And that was to consider whether or not the defendant killed Deshaun while he was committing or attempting to commit aggravated robbery.
Mr. Gillette, when would it ever not be harmless under your theory to give self-defense? And not to give self to, under your scenario, as long as there's a guilty verdict to the felony to felony murder with some sort of understanding that the jury considered the underlying felony as a forcible felony, it would never be harmless, or it would never result in anything but harmless error.
I do want to be extremely clear on this point, Justice Rosen, because while I can't hypothesize on every possible scenario, what I can tell this court is that the record here is definitive that if this was error, it was harmless. Now, one possibility that I've been able to come up with as a potential hypothetical is if there were possibly a defendant that tried to claim alternative defenses, or if they're more to the point, I think the better example would be if there was some additional error. If there had been some additional error in instructing on the elements of the underlying offense, then possibly we could find a record that there might be some harm. But the important question for this court today is this case, and that's what I would prefer us to focus on, obviously. But I think that brings me around, and I want to talk about what Justice Biles suggested. I think that his suggestion is how we could order the instructions and then tell the jury to just skip the self-defense instruction if they determine that the defendant is engaged in a forcible felony. I think that that's appropriate. I think that's what the
how would the jury
do.
consider under that scenario, as Justice Biles was made his observation? How would a jury consider self-defense if you first consider whether the forcible felony was committed? Wouldn't that have to be part of the deliberation as you're considering the forcible felony?
I don't think that that's accurate, because the first question is whether or not the defendant is engaged in a forcible felony, because if he is, self-defense as a matter of law is unavailable under our statutes. So I see Justice.
I presume that.
Go ahead, Justice Stegall.
Sorry, I couldn't tell if I was talking over someone. I apologize. I presume from the comment you just made, Mr. Gillette, that you disagree with opposing counsel's answer to my question about whether or not self-defense has any impact on the underlying forcible felony. I think the argument we've heard is basically that we as judges after the fact can't kind of come in and do an autopsy on what happened and parse it all out, because what really happens in a jury room is they have all this stuff together at the same time. And so self-defense does in fact impact the underlying forcible felony, even though we know in sort of a pristine legal environment that it doesn't.
I do disagree with my opposing counsel's analysis of that issue, because for two reasons. Number one, this court does presume that juries follow the instructions that they are given. And number two, I don't think that we can speculate on how a hypothetical may have hypothetically impacted the jury deliberations.
Well, when we're dealing with the defendant's rights to present a defense, and again, I know you have an argument that there was no error here, but let's just assume that we're going to conclude, as we already did, that there was an error. Why not just send it back and let them do it the right way? Because I guess I'm asking you to respond more directly to the claim that juries, that we really can't look at what happens in a jury room in this sort of what I described as pristine legal environment, and just say, well, they found ag robbery, so harmless as a matter of law. When the reality might be that giving the self-defense instruction could have changed the entire dynamic of the discussion amongst the jury.
My direct answer is there's absolutely no indication that giving a self-defense instruction could have changed the dynamic of this jury. There is absolutely no indication of that in this record. And to that point, my opposing counsel acknowledges rightly that the jury would have been given both the self-defense.
Well, jury rooms are a black box. Like there's never a record of that. We don't know what happens. That's why our review of instruction errors has this really high standard for harmlessness.
Correct. They are a black box. The only thing that this court can find that this jury did is, number one, they didn't ask any questions. And number two, they returned a verdict that told us exactly what they would have done, even if they had been given a self-defense instruction, whether they had been given that on its own or whether they had been given that appropriately with the additional instruction or two that typically carry along with a self-defense instruction. Because again, the evidence that they had before them is the exact same that would have potentially justified a self-defense finding. They evaluated that because it was a pure credibility question. And that is the entire reason that I set forth in my request for this court to rehear this case. It's a credibility question that has been answered definitively by the jury's finding in this case. And I know that doesn't necessarily erase the hypothetical or the potential error that occurred, but it does allow this court to evaluate the entire record and find that potential error to be harmless beyond a reasonable doubt under even the constitutional standard in this case. If I may have a moment, Chief Justice, I see my time is up.
Yes, continue.
All right. Thank you. Just a couple of points that I'd also just briefly wanted to touch on. The argument that the jury's options were guilty or not guilty, that's always the question, is whether the defendant is guilty or not guilty. A self-defense instruction would have still left us with the jury having to make that choice. And again, I would reiterate, they've told us what they would do definitively. And again, a jury, based on the evidence in this record, the jury wouldn't have even been required to argue and weigh a theory of self-defense. I understand that this court's potential assumption of error. Finally, just to note that that the failure to give a self-defense instruction would somehow neatly clear the way for a nearly trouble-free prosecution. I disagree with that based on the record in this case. This was not a trouble-free prosecution. The state had to prove every element of its crimes, including that the defendant was engaged in the underlying forcible felony when he committed a killing. And through that proof, we know that the jury would have rejected a self-defense claim again because the evidence was the same, and they've evaluated it and told us what they would do. So the state respectfully requests that this court reconsider its initial opinion. I thank you very much for granting us the opportunity to speak to the court once again on this matter. I would ask initially that this court consider the appropriate standard for whether or not a self-defense instruction is warranted, and to clarify that in light of Haygood and Bartlett. And ultimately, even if this court is to find that there was an error in not giving the self-defense instruction in this case, that it be found harmless beyond a reasonable doubt. If there are no other questions, once again, thank this court for its time.
Thank you, Mr. Gillette. Ms. Davis?
I think the only additional points I want to argue from my original argument is that if you don't instruct the jury on the law applicable to the defense case, then trial counsel can't really argue that to the jury in closing argument. So basically, what you're getting is everything, the argument is all about the state's case. So that's another thing to consider. The state says, well, sure, Mr. Holley got to present his evidence to the jury. But there's a reason we have closing arguments. You got to be able to argue how the law applies to that evidence. And when you don't give the instruction, defense counsel can't do that. And then the other point is then the jury doesn't have to really consider and deliberate it. If you just give them felony murder or not guilty, they don't really have to think about the defense theory of the case. They don't really have to sit there and argue with each other. And that's what we want juries to do. We want them to go over the evidence with a fine comb. We want them to consider it. And if you don't give them the instruction, then they're not forced to do that. I think the other point that I wanted to make is I don't know how you instruct the jury that the state has the burden to disprove the defense if you don't instruct on the defense.
You know, Ms. Davis, I did want to talk about that, and maybe I'm just, I'm not really getting, I'm going to go all the way back to Justice Stiegel's very first question. Procedurally, what exactly would you want in the progression of the instruction? Where does the self-defense come in here?
So basically, if you look at the 3 pattern instructions that are appropriate, the pattern instruction right now says the defendant raises self-defense as a defense. And evidence in support of that defense should be considered by you in determining whether the state has met its burden of proving the defendant guilty. The state has, I'm paraphrasing here, but the state has the burden to disprove the defense, and that burden never shifts to the defendant. All you're doing is you're just giving them the legal theory. I mean, there's no ordering here. You're just telling them
how
the
does
legal
that play into, you know, the forcible felony? Because it seems like what you're trying to do is say, look, we want the jury. I mean, your bottom line is we want the jury to more scrupulously review who was the robber here, right? Because that's, you know, that's your issue. But there is no, that's not self-defense. That's just a disputed issue of fact. Because he's
That's
not.
correct. That's correct. I'm not disagreeing with that. That's all the jury got in this case. They didn't get self-defense. All they got was the state has to prove robbery. That's all they got.
That you're not asking for a self-defense instruction on the forcible felony, ag robbery, right? You're not seeking self-defense on that. This is really not self-defense. Your goal here is I want them to consider the defendant's version of the facts that he was the victim. We're not talking about any murder here. We're just talking about whether he was engaged in a forcible felony. And what I don't understand is how self-defense comes into that.
Mm-hmm.
It seems like, you know, that what would be, it seems like you're not arguing self-defense. You're arguing sufficiency of the, you know, well, not sufficiency of the evidence, but you're saying, look, the jury decided that underlying question without considering, without scrutinizing carefully whose version of the facts is.
Right, but
go ahead.
I think the best way to say it is you walk into this trial and you're characterizing it as a robbery or not. You're walking into this trial and Mr. Holley's saying, I did this act. I shot this man. The state's theory is he shot him as part of a robbery. Mr. Holley's theory is I shot him in self-defense. So that's what the trial is all about.
Right. So you're saying the trial is all about the robbery.
No, the trial is all about whether my act of shooting this man was justified or not.
And what's that based on?
From the defense point of view.
What's that justification based on?
Self-defense. And that's what Mr. Holley didn't get.
No, but felony murder.
That's the state's theory, though. That's the state's theory.
Well, he was charged with felony murder.
Right, but it's not up to him to disprove that. It's up to the state to prove that. His thing is, I'm admitting that I did this killing. Right? It's not up to him to disprove the robbery or not. That's the state's theory of the case.
Right, and the state is saying, look, we proved, here's all the evidence.
Mm-hmm.
You must, you know, it says you must prove beyond a reasonable doubt, beyond a reasonable doubt, you must believe that he was the perpetrator in this robbery.
Right, but I think that's the case that I cite in my supplemental brief, where it's very nuanced. And depending on who you believe, this could turn into a case of self-defense, or this could be a forcible felony. It could be either one. Right. But if you don't give, again, we're going back to, I'm not disagreeing with the logic. This is all very logical. I'm not disagreeing with the logic of saying, well, he was found guilty of felony murder, so therefore self-defense wouldn't have applied. That's true. 2 + 2 = 4. Yes.
Well, I think more what they're saying is that he was found guilty of aggravated robbery, being the perpetrator, right?
And
He
there-
was
and-
found
yes.
out beyond a reasonable doubt, and because he was found guilty of a forcible felony, a defined forcible felony by the statute, then self-defense to felony murder is not available to him.
Right. But again, we're just going back to my balancing equation. And was it Mr. Holley's version of events more believable than the other version of events? If you instruct on the law, that drops off. Because at this point, the state has to disprove that he acted in self-defense. They have to disprove it. And all it takes is one juror with reasonable doubt to say, gee, I kind of believe the state's version of events here. It looks like he was the one committing the robbery. But Mr. Holley's given me enough that I have a reasonable doubt as to whether he acted in self-defense or not. And that's the part that was missing in this.
Well, no, but a
case.
reasonable doubt about whether he was the perpetrator or the victim in the robbery.
Right, but the jury wasn't told that. They weren't told that. They weren't told that the state has the burden to disprove his defense because they weren't given the defense.
Right. So what jury instruction would you want to say? Look, a precursor jury instruction that said, first you need to find, now I know it wasn't charged separately here, but first you need to find whether or not, who was the victim and who was the perpetrator in the robbery.
I'm not asking for any change in the pattern instructions. I'm just asking that you give the pattern instructions. The state invited the error in this case. The prosecutor did. If the defense attorney invited the error in this case, we would never even be arguing this. You wouldn't even consider it. You got a prosecutor that misapplied the law. You got a judge that misapplied the law. So you have a man who went to a jury trial claiming self-defense, never got instructed on the law, never got to argue that to the jury, never got to have the jury deliberate it and weigh that against the state's case, and never got the correct burden of proof instruction. I'm saying under those circumstances, you should grant him a new trial. That's what I'm saying. I'm not arguing for any change in the pattern instructions. I'm just saying there's a bunch of people that erred here, and it was a state and it was a judge, not the defendant.
Thank you.
Let me ask you, counsel, if we take a step back in the process, if the evidence supports self-defense is objectively and subjectively reasonable, is there a situation where the district court is still able to deny the instruction based on the conclusion that there's no affirmative evidence defending against the underlying forcible felony? When would it be appropriate for a district court judge to still deny the instruction despite your evidence of subjective objective reasonableness based on the conclusion that it was during the commission of a forcible felony?
It just wouldn't. It wouldn't, because that's a jury question. That's a jury question.
Right. So that your position is that's a question of fact that would never be decided by the district court at the instructions conference.
That's correct. That's correct. So I think I've vehemently, strenuously argued our position. And so that would conclude my comments unless there are further questions.
I'm not seeing any, so thank you. And thank you to both counsel for your arguments this morning. The court will take this matter under advisement. We are now in recess until